I'd like to introduce our next speaker, attorney Kristin Kelly. Kristin practices both in family law, but also in business transactions, including trademark. And she joined the firm in 2019, graduate of Seattle U Law School. Prior to law school, she worked for several years in different capacities in law firms. So she's very familiar with lots of the many areas of law and brings with that experience, insights into working with her clients. She's going to be talking about community property, which Washington, of course, is a community property state. It comes up not only, of course, in the family law context, but in the estate planning context. So delighted to have Kristin address this important issue. Kristin.
Thank you, Mike. On the coattails of that, I will not be providing any kind of legal advice regarding what happens to community property upon death, only upon divorce or separation of parties. Hello, everyone. I'm Kristin Kelly. I'm an associate attorney here at Reed Longyear, Malnati, Corwin, Burnett, and I'm here to talk to you about community property, the presumption, the common misconceptions, and potential exceptions. Next. As many of you may know, Washington State is a community property state. Essentially, what that means is that income earned and property acquired during a marriage is owned by the marital community itself. Next slide. When a marriage ends in Washington and the parties want to divide their property, the court will presume all income earned and all assets acquired during that marriage is community property and community debts. And the court has the authority to divide that property between the spouses. While this may not be news to most of you, one thing you may not be aware of is that community property can be created by two parties who are not married, but are living together in a marriage-like relationship. The term used for this in family law court is a committed intimate relationship. Many people are shocked to learn at the end of a very long relationship where the parties never married, but lived essentially like they were, one of the parties can file a petition with the court asking the court to divide the community property that was created and divide it equitably between them. Next slide. In my practice, I meet with individuals at all stages of their life and relationships. I meet folks when they are planning to get married and want to negotiate how community property will be created during their relationship. I meet with people simply who have questions about protecting their separate property before or during their relationship. And I meet with people at the end of their relationship who are trying to understand what happens next. Will they be okay? Will they be left with nothing? In these meetings, I have found there are a lot of misconceptions around how and when community property is created and what will happen to that community property upon divorce. One such misconception is that when you get married, all property automatically becomes community property. This isn't true. If one party owns a home when they marry, that home does not automatically get converted to community property just because they said I do. If a party owns a car prior to marriage, it's still that party's separate property after the marriage license is signed. There are some ways these assets could eventually become community property, or that the community could potentially create an equitable interest or lien in this property, but the marriage itself does not automatically convert property into community property. Along the same lines, folks often think that if one party's name is on a deed or a mortgage and not the other, it's not community property. Or conversely, that if their name is on a deed or a mortgage, it must be community property. However, title does not control whether or not the property is community or separate property. Whether it's community or separate will be determined by the court despite title, and the principles we're talking about today will have much more bearing on how that determination is made. Another misconception is that the court can't touch your separate property or your spouse's separate property. This is also not true. While the court doesn't make a regular habit of awarding the separate property of one party to the other, the court does have jurisdiction over all the property, community and separate, of both parties. And if the court believes it's necessary for an equitable division, it can award separate property of one party to another. I bought it with my money. This is generally a misconception and probably the most common one I encounter. Many people believe that their income is their own separate property. More and more couples these days are keeping their finances separate, their income separate, or have a community account, a joint account, and a separate account. They come to me saying, I paid for that with my money. The problem is, unless you have a relationship contract where both parties agreed in writing that their income would be separate property during their marriage, it's not. It belongs to the community. Their employment benefits too. It doesn't matter who worked harder, who earned more income. It's all community earnings and community assets. Another misconception is that community property means that the court must divide property 50-50. While that very well may be the case, it is not a hard and fast rule. The standard the courts use is actually fair and equitable, which is not the same as equal. Sometimes the court will award a disproportionate share, which is anything other than 50-50 of the community property, if that is what the court believes is fair and equitable. There are many potential considerations that the court could rely on to award a disproportionate split of the community property. Next slide, please. One example is when one party has a significant separate property interest and the other party has no separate property interest, or a very small separate property interest. The court could decide that one party gets more of the community property because the other party has so much of a separate property in order to make it an equitable division. Another example of when a court might award a disproportionate share of community property to one party is if the court determines that one party has dissipated or wasted community assets, leaving less for the community to divide at the end. In that case, the court might award more of the community property to the party who did not waste community assets. The court has done this in cases where one party wasted community assets on extramarital affairs. They've done it when there's gambling and also alcoholism. Though I will point out that this case is much less common and is reserved for pretty specific cases. Another reason may be because of the nature and the limitations of the assets. Maybe it's not feasible to divide the property exactly 50-50. An example of this may be that the largest asset of the community is a home, and one of the parties is raising the children in that home. So the court decides it's not equitable to force them to sell the home for an equal split of the property and awards the home to the party who's raising the children in it. Other considerations the court may rely on in determining what is fair and equitable. The length of the marriage. Courts treat marriages, short marriages and long marriages very different when it comes to dividing property. Future earning capacity of the parties. The court will take into consideration whether or not each party is able to provide for themselves at the end of a marriage and their ability to earn more in the future. Assistance in putting one spouse through school, the contribution of separate property funds into the community that's being divided, and professional educations or licenses acquired during the marriage. The court will often want to make sure that a marital community receives sufficient compensation for the investment it made into that party's career. Next slide. Now, just because there is a presumption that everything acquired during the marriage is community does not mean it actually is. There are several exceptions to this very general rule. Essentially, it's each party's job to demonstrate to the court how and why certain assets or income are not community property, but in fact their own separate property. This is by no means an exhaustive list, but some exceptions to the presumption include an inheritance received by one of the parties. If one of the parties receives an inheritance to them individually from a friend or relative, and they can show the court that those funds or that asset have stayed separate since they received it, has been kept separate from the community, the court will generally find that it is the separate property of that party. Similarly, if one party receives a gift solely to them, and they've kept that asset or those funds separate from the community, and they can demonstrate that for the court will generally find that that's the separate property of that party. As I mentioned before, just because a person gets married does not mean their property automatically becomes community property. So neither do the gains on that property or profits and rents from that property. So for example, if a person came into a marriage with a home they bought previously, and they decided they were going to move into a new home with their new spouse, and they just rent out their old home for 10 years. And at the end of that 10 years, the parties separate. The increase on the value of that home and rents received, if kept separate, would potentially be separate property if that party can show to the court that it was kept separate. Next slide. I think that's all the time I have today, but here are the takeaways. Community property is property acquired during a marriage or a committed intimate relationship, and the court can fairly divide that property at the end. The court considers many facts when deciding how to divide property fairly and equitably, and it may not mean 50-50. If you want to establish how community property is created in your relationship, you can negotiate that in a relationship contract so that there are no surprises later, whether it's entering into a committed intimate relationship or a marriage. And finally, keep your separate property separate and keep your records. Thank you so much.